Hello and welcome. Good evening, everyone, to CAN Foundation's webinar today. Today we have with us the eminent jurist, Mr. Harish Salve. It has been much of a pleasure of hosting him with us on this platform. Without further ado, I'd like to invite upon Mr. Siddharth Gupta, the CEO of the foundation, for an introduction of our guest today.
Good evening, everybody. Today we have with us Mr. Harish Salve, eminent jurist and senior advocate with us. I would just like to go on with a brief introduction of his. To start, don't limit yourself to only the sky. Strive higher with God. He has no limitations, for the sky is just the beginning of endless possibilities in this universe. So said the renowned poet, Mr. Pauline Seapourt. What personifies this beautiful quote before me and allows me to comprehend its meaning even better is the kind presence of one of the illuminating minds of our country today, Mr. Harish Salve, a repository of knowledge and wisdom in himself, an embodiment of humility and grit. Sir, I run out of words when it comes to introducing you. Where to start and where to finish is an enigma we are confronted with today, given your countless contributions to the legal fraternity and society at large, which may allow us to describe the magnanimity of your personality and encapsulate your achievements. Though unsuccessfully, we would count a few amongst the million drops in the reservoir of achievements in your career spanning over 40 years in the profession. From serving as Solicitor General of our country to appearing in some of the renowned cases representing major corporations like Reliance Industries, Tata Sons, ITC, etc., Salve sir has innumerable landmark victories under his hat. He also bears the distinction of arguing the first anti-dumping case in the Supreme Court of India. Additionally, he has also appeared for Bilkis Bano, a victim of the Gujarat riots at the behest of National Human Rights Commission. In May 2017, he represented India before the International Court of Justice in the Kulbhushan Jadhav case. His impeccable submissions persuaded ICJ to grant a provisional stay on Mr. Jadhav's execution till the final outcome of the matter. This was a feat which has not been achieved by any counsel from our country on the international platform like ICJ. Mr. Salve, representing Mr. Jadhav, reminds us of a famous saying of Mr. Mahatma Gandhi, late Mr. Mahatma Gandhi, that the best way to find oneself is to lose oneself in the service of others. India Today Group ranked Mr. Salve amongst the top 10 most powerful people in the year 2017. Having been appointed as the Queen's Counsel, United Kingdom in February 2020, Mr. Salve happens to be the only Indian to be part of the Queen's Counsel to practice in both United Kingdom and India collectively. Sir, having you with us today at CAN Foundation, which is still evolving, swells up our hearts with pride, gratitude, and honor. On behalf of the foundation, I must tell you that this foundation is conceived with the objective of reaching out a helping hand to the economically weaker but bright and meritorious students in the form of scholarships. The foundation, under Project Eklavya, in the present year has already disbursed a scholarship of, in its maiden year of formation, has already disbursed a scholarship of 14 lakhs to around 13-14 students from various NLUs. The foundation has started the first of its own kind project in the country titled as Project Dhananjay for launching some of the ignited minds into litigation by paying such students, fresh graduates, monthly stipends from the corpus of the foundation. Today, hosting you as a keynote speaker has bolstered the faith of everybody associated with our foundation, in our foundation, that we are perhaps moving in the right direction. Once again, we express our indebtedness to you for being our guest today. Our moderators today are Mr. Avishkar Singhvi, and the vote of thanks shall be given by our foundation executive committee member, Mr. Abhikal Pratap Singh. About our moderator, Mr. Avishkar Singhvi, he is an independent counsel practicing at the Supreme Court of India, Delhi High Court, and National Company Law Appellate Tribunal. He started his practice under the stewardship of Mr. Shyam Diwan, where he worked from the year 2012 to 2014, immediately after finishing his graduation. He then worked with Agrawal Law Associates before doing and venturing out with his own independent practice as a litigating counsel. He has also represented state governments such as Madhya Pradesh and West Bengal before the Supreme Court of India and Delhi High Court in several matters. He has been actively involved in several highly significant matters over the last few years. He is also a regular panelist on television debates on various channels, providing his legal inputs on various issues. Mr. Avishkar, we are really thankful also to you for agreeing to moderate in the session on such an intriguing issue. About Mr. Abhikal Pratap Singh, he is our executive committee member, an alumnus of Ram Manohar Lohia National Law University 2013 pass out. Mr. Abhikal Pratap Singh worked initially with Mr. Gaurav Agarwal, advocate on record, followed by his two-year stint with Mr. Shekhar Nafde, senior advocate. Today, Mr. Abhikal Pratap Singh has established an independent practice of his own as advocate on record before the Supreme Court of India. With this introductory note, without taking much time, I would request Mr. Avishkar Singhvi to take over the mic.
Thank you, Siddharth, for a warm and rather modest introduction of Mr. Salve. I wish to thank Sir for agreeing to discuss and surely enlighten us all, along with all our viewers that are watching today's webinar, on a topic that's been a great cause of concern all over the world. I welcome all the viewers of this webinar. We hope to have a fruitful discussion. I will not add to the list of monumental accolades to Mr. Salve's enriching and illustrious journey as a legal counsel. Through decades of legal practice, sir, your journey as a lawyer is inextricably intertwined with the evolution of Indian jurisprudence and therefore of seminal importance for future generations. My own personal experience of interning with you just less than a decade back was a daunting experience for a newcomer to see such immaculately high standards of advocacy that would almost to a point where it became discouraging for me. One such example was when in the Vodafone dispute before the Bombay High Court, where the depths of your arguments were a treat to watch for any aspiring lawyer. Before an honorable justice who now presides in the Honorable Supreme Court, I have had the opportunity to assist you subsequently over the last 5-6 years, and experience have been highly rewarding, sir. I would like to say further that Mr. Salve has also passionately stood for many causes and currently plague our system, totally unselfishly. For example, environment being a prime one. Not too long ago, sir, you have spoken candidly regarding the abuse on social media platforms pervading all through the system, and especially regarding the judiciary. While during a hearing of 3 distinguished Supreme Court judges expressed their anguish at the repeated attacks on social media, they sought your suggestions on what should be done. Today's topic is the insulation of the judiciary from social media diatribes. After all, we must defend and protect those who defend us all. In the present context, we must lay emphasis on the word diatribe or a vituperative verbal assault and distinguish it from what may be labeled as beyond legitimate criticism of a ruling or official actions of any judge. Voltaire was expressed by an author of his biography, namely Hall, to state, "I may disapprove of what you say, but I will defend to death your right to say it." It makes the task of the judiciary even more difficult, where it must, on the one hand, jealously guard sacred freedoms such as free speech and expression, and on the other, it must not allow the reputation of the institution to be irretrievably tarnished. It also must ensure that the delivery of justice is not hampered, and the dialogue between judges and lawyers is sustained. It is indeed a tightrope walk. Though it is true that private remedies may be available for individuals to seek protection in the form of injunctive relief and damages arising from undue, harsh, and slanderous statements made against him or her in her private capacity. However, where the entire reputation of the institution is at stake, should there be an overarching need for specialized and efficient regulation? With the excessive use of internet today, width and reach of information is limitless. Even though this is a great boon, sir, it is also an equally sinister curse. The anonymity of the internet allows several individuals to write and disseminate posts that may be highly distorted, maliciously false, and even obscenely abusive, without having any responsibility for their actions. One of the great dangers of social media is the rampant invasion of privacy by agencies and not solely by the government. Actions such as posting, trolling, and viral circulation in less than seconds of any piece of information that relates to the private life and integrity of any respected citizen, like a judge, without any prior notice, albeit, this urgently needs attention as it plagues the very founding institution of any democracy. At times such as today, whistleblowing though creates transparency, but not on most occasions, where it hampers the delivery of justice. The belief of the population in the judiciary as a whole must not be shaken, and who must undertake such duty? What is the fine balance between constitutional freedoms and institutional independence? We shall endeavor to answer certain factual and conceptual issues that arise extremely often today, such as when such posts relate to the judiciary in matters where the delivery of justice is directly and severely hampered, what must the court do? Where the identity is known and not disputed, the remedies under IPC and IT Act available are sufficient or not. The post can merely be blocked and the remedies so pursued. Sir, in this background, I wish to ask you a first question as an introduction. My question is that what, in your view, sir, could be labeled as a diatribe or a bitter vituperative verbal attack that is beyond the limits of free speech? Any illustrations or bright lines between, on the one hand, creating an environment of judicial accountability through legitimate criticism, and on the other hand, contemptuous posts that hamper the fair administration of justice would be really helpful, sir.
Thank you, Avishkar. Thank you for the question. If I may just, in a moment, express, first of all, my delight about your organization. I have always almost envied all the students who come out of national law universities for the kind of education which they are receiving. I have always felt my lack of education as a serious limitation and tried to catch up. Because as you know, in our profession, you are always a student. And I've always felt there are so many in our country, perhaps brighter than all of us here, but who don't get the chance, who don't get an opportunity. And if opportunities were made available, it would be so wonderful. And I'll just share one instance with you. I started ad hoc at the request of Miss Frances Cairncross, who used to be the rector of Exeter College in Oxford University. She said there's a very bright girl from Delhi who cannot afford our fees. She has got part scholarship, part she cannot afford. Can you help? And I knew Francis and I agreed to help that young lady. She used to live in Vasant Kunj. Hardly did I know. That time I used to live in Vasant Vihar. She used to live half a mile away from a middle-class family who couldn't afford the 40,000 pounds it would have cost over and above the scholarship she had got. I was so happy that young lady passed with flying colors. She went in for her graduation, her post-graduation. I helped her in that. She did international tax law. And guess what her subject was in international tax law, which she didn't know I had anything to do with. She did international tax law with the Vodafone case. And so when we were arguing it in Supreme Court, I told her, you can come and sit and hear submissions for a few days. She's, of course, done her doctorate in international tax law and moved on. I think she's now a professor in Oxford, unless she's moved on further. So this is a story, and there have been a lot of others like her. This is a story I always recall with great pride of what Indians are capable of given the opportunity. And I'm happy there is an organization in India which is helping students who have the skills but not the economic means to acquire education, because you are doing the biggest service to the cause of jurisprudence, to the cause of development of law. Ultimately, our system, the integrity of our system and the strength of our system must rest on two strong pillars. One is its integrity of character, and the other is the integrity of its intellect. And unless you have both, you will not have the kind of judicial system which a country like India needs and deserves. which drops me down to the point which you raised. The law of contempt apart, if you step back for a minute and see what is it that we are talking about and what is it that we want to protect society against, not just the courts, I think we get all the answers. The judicial institution in India today has come to acquire in the common man's mind space a unique position. And in certain respects, a lot of the frustration the citizenry feels by poor governance is addressed by a feeling that, well, you can go to a court and get relief. May it be at an individual level, may it be at the level of a person who has been treated badly by the system, or may it be now through the form of public interest litigation. So this institution becomes as important as an institution as Parliament. I have always said the court is no higher than Parliament, but no lesser than Parliament. And if we keep this in mind, we then go to the next step. What is it that we are trying to protect? Criticism of an institution may be hurtful to those who for the moment occupy office. But if the criticism is of the kind that at the end of it, the institution will emerge stronger, that criticism is justified. That it is addressed in words which may be in questionable taste is never a ground to circumscribe the content of that criticism. You may criticize the language, but you must preserve the right to make that criticism. A criticism which is meant to undermine the authority of the system, which is meant to undermine the court. And when that criticism undermining the court is made by those who have sway over public opinion, that is, I think, something which undermines one of the pillars of democracy. And that is a criticism which must be dealt with. As you know, the famous story when the famous Blackburn cases, which are the turning point in English jurisprudence, and although they moved away from it, we have developed that further. For the first time, the English courts, one Mr. Blackburn went to the court and said, I want the court to issue a direction to the police to enforce pornography laws in Soho. And the usual answer would have been, who are you? And how are you affected? And he said, I'm a British taxpayer. And I'm entitled to see that the law is enforced. And Lord Denning in the Court of Appeal upheld his contention and said, yes, he has the standing to seek a direction to the police. And at that time, there was a very eminent jurist. At that time, he was known as Sir Quintin Hogg, who later became Lord Hailsham. He used to be Lord Chancellor. He was a very eminent silk. For long years, he was Lord Chancellor after that. And he's author, as you know, of the Hailsham edition of Halsbury's Laws of England. So Mr. Quintin Hogg, as he then was, wrote a stinging rebuke of the court, saying, what have your judgment, what do you do, and what are you going to achieve by all this and by opening these floodgates to allow this kind of a criticism? So Mr. Blackburn was back in court saying, Mr. Hogg has committed contempt. And the Court of Appeal reversed and threw his contempt out. And Lord Denning said something very important. He said, contempt is not to protect our dignity. It must rest on surer foundations. Contempt is to protect the institution and to prevent interference with the course of justice. So if we keep these big guidelines in view, anything which undermines the institution rather than criticizes the institution. That has to be where we stop. That is where the freedom of speech ends. And that is where you cross the bounds of legitimacy. And not only you can, but you should bring the might of the law down on such criticism. Let me give you an example which is uncontroversial. I read in the newspapers, the Andhra High Court has issued notice. I asked a friend in Hyderabad to send me the kind of comments which led to this notice being issued. Those were by people in public office or people belonging to a particular political party. They were not critical of any judgment on the ground that it was wrong on principle. They were not critical of the institution saying you should or should not have done something. They are abusive and they are a defiance of the authority of the court. They are a challenge to the majesty of the constitutional institution we call the High Court. To say, who are you, judges? How dare you interfere? We will put you in a room with a COVID patient. You will be slaughtered, you will be killed, we will kick you out. And using language, not only the language was questionable, but the content is questionable. If you are saying that a judge should be thrown out of his house, a judge had no business to pass a particular order, how dare he quash this order? How dare you do this? Who do you think you are? The arrogance of office or the arrogance of being in a party which is in power in a state, if that is driving you to challenge the institutional balance and you are in a position to influence public opinion, what you are trying to do is challenge the system. What you're trying to do is challenge the court. And that is what this power is conferred for. And if those allegations are true, I hope sincerely that the High Court deals with these people firmly. So this is where the distinction lies. It is not, you can criticize a judgment. You can criticize the judge, as you know of the famous story about the Daily Mirror, which called when the spy catcher contempt was issued against Times. The Daily Mirror said 5 old fools. And one of the judges, when he was asked, one of the law lords, when he was asked, Falinariman's favorite story, when he asked him, why didn't you act? He says, what's wrong? What is there to act? 5 is accurate, old is accurate, fools is a matter of opinion. So if you say something like that, saying why should, these people should not have granted the injunction, you're in the 21st century, this is, their notions are antique. Of course, what you're really doing is criticizing the judgment. But if you were saying those judges were towing a party line, or those judges were being subservient to the government, you're attacking their honesty and integrity. You're not attacking their judgment. I can criticize the judgment as saying it is too conservative. Shivkant Shukla's judgment was criticized saying it was horrible law. You can say that. You can say, I'm sorry, the judges have taken such a conservative view that they have made rule of law subservient to tyranny. That's a valid criticism. But to say that those judges acted like this because the motive was that they were scared of the government, you're treading on dangerous ground.
Yes, sir.
And this is particularly relevant today, where I think everybody who has a point of view thinks the Supreme Court is a national dartboard on which everybody who has a point of view has the right to throw a dart. And this must stop.
Thank you, sir. That's really valuable takeaways from that, sir. Firstly, sir, you said that undermining the majesty of the institution and undermining the authority that is vested in judges is a very important takeaway, sir. And that is the line. Criticizing on the basis of sane reasoning is what we should look at, not on the basis of ad hominem personal attacks. So I would, before going to the Indian context, I would take a few examples from the international system, and I would see what you feel about them, and take your thoughts on those. Recently, President Trump criticized the judgment delivered by the District Court of California, which actually ruled that the president's proclamation for asylum seekers was against the expressed intent of Congress, and further creates irreconcilable conflicts with prevailing law. The US president termed this ruling to be ridiculous. He referred to the judge as a so-called judge. He then went on to state that just cannot, and I quote, just cannot believe a judge would put a country in such peril. If something happens, blame him and the court system. People pouring in bad. The president even accused several Ninth Circuit judges by questioning the intentions, credentials, and also cast aspersions on the independence of the judiciary. Several judges and senior members of the bar have spoken out against such attacks on Justice Robart, who was a target of these political attacks. And he said this, sir. Here's the president of the United States saying that this person is not a judge, implying that you can disregard his ruling, and saying that these people are flooding into the country to rape your wife, rape your children, and it's all his fault. I think that crosses a line from legitimate criticism of a ruling and goes into a whole different area. Similarly, sir, Justice Maureen O'Connor, Ohio Chief Justice. So I'll just take two examples, and then, sir, I'll just take your thoughts on it. Maureen, who said, Ohio Chief Justice, who said that judges who are under attack have to speak up, and their fellow judges and the Bar Association, they have to do it continuously. We have the duty to speak up to protect the institution and thereby protect ourselves. Your duty to speak up and protect the institution should not be blanketed and smothered by the concept of your doing something that is against your ethics if you speak up. It is your duty to do so. And lastly, sir, Washington Supreme Court Justice Deborah Stephens said that the erosion of public trust is seen across all branches of government, but the judiciary is a unique example in many ways. She said, I quote, "What we experience in courts is a result of the fact that we are the place where the littlest dog gets to lift his leg against the biggest tree." Several judges recounted recent threats and attacks on the judiciary from high-level officials, including governors, legislators, mayors, police chiefs, etc. Such attacks are a chilling desire on the young lawyers to become judges, and these are very personal and sometimes have a terrifying impact. You can't do things the way you've always done. It's cut off. Hello.
I can hear you. I can hear you.
These are very personal and sometimes terrifying attacks are having an effect. You can't do things the way we've always done with our lips sealed and just talking in platitudes. We have to take more aggressive actions. So, sir, my question in this background is, should judges be left to the task of defending themselves by speaking out, or a different mechanism can be created with the sole responsibility of fighting this menace? The powers can be granted by Parliament to an existing body as well, sir. So what are your thoughts on this?
I think what the example you raised really underscore that the problem which we are seeing in India is a pandemic. It's a pandemic against the existing system, and each country has to find its own solution to this problem. No right-thinking person can uphold, can support, or even swallow the tone and tenor of President Trump's comments. I mean, I may be saying something which may apply to a very large number of his comments, but the ones addressed to judges, there cannot be a greater abomination than in a country as America, where the judiciary is so robust, that the president of the country criticizes a judge, not because if Trump had stopped at saying, I have read the judgment and I think it is ridiculous, I would have said it is bad language, but the content is justified. If Trump had said that the consequences of the judgment are going to be horrendous for the country, that's legitimate criticism. I have publicly said that a judge who is now giving grades to the Supreme Court post-retirement, some of his judgments have been disastrous for India. If our GDP has dropped 1%, Supreme Court must get part of the credit for closing down mines, for closing down industries, for closing down collieries. And some of the judgments are deeply legally flawed. And very clearly, they show that the court took a view which was very difficult to sustain. But it's a wrong judgment. One can use language to criticize. You can say the judgment is wrong. You can say the judgment is horribly wrong. You can say certain judgments display a mindset. That's a legitimate criticism. You can say certain judgments show that the approach taken is very suspicious of business, very suspicious of industry, or an approach taken is unduly pro-environment or unduly conservative and anti-environment. All those are all legitimate criticisms because they are directed against ultimately the judgment. The moment you go further and say disrespect the judgment, that is where you are crossing the line. As you know, in the spy catcher cases, a very interesting question arose. When there was an injunction against 2 newspapers and certain other newspapers, the Times went and published the same extracts. And a question arose whether the Times could be held guilty of having committed a contempt of court. And their defense was, but there was no order against us. The House of Lords said no. If you are aware of an order of a court and you take steps in a way that you destroy the worth and value of that order, in certain cases, you may be liable on contempt. So if you are, why? Because you are destroying the sanctity of an order of court. Now, if the president of a country starts saying, what sort of an order is this? And virtually at times have said, we are not going to obey this order. I have seen in Andhra, some of them have said, why should we obey this order? Now, what are you inviting people? You're inviting people to say, why should we obey orders of the court? You can say this judge is horribly wrong. He doesn't know basics of law. Terrible language. Basically, what you're saying is that the judgment is wrong in law. But to say that the judge, for example, in India, what is very common, this judge is delivered because it shows his high caste bias or his low caste bias or his caste bias or his religious bias. The moment you say something like that, or worse, you say this judge is dishonest, you are then casting a serious aspersion on the system, that the system is manned by people who don't decide on law. You may decide on law, and while deciding on law, you may decide rightly on law, you may decide wrongly on law. But to say that you're deciding on a motive is highly objectionable. I have this serious objection. I read, and I want to bring this up. I read the Solicitor General's comments in court on the Migrants case. And while it may be very popular to call him names and condemn what he said, I think what he has said calls for some serious thinking. There are people who go out and say the Supreme Court is hopeless, the judges are useless, and the court is not going to give you justice, and the very next day they are back in court. Should the Supreme Court be supporting them? There was an article last week, which I read in the Financial Times, where somebody has said on the migrants issue, you cannot support what is going on in India. No Indian court can give you justice. You must have an international tribunal. And an Indian is writing that. Now, things such as this, I mean, one is best to ignore these people because the people who are writing they're best ignored rather than being made popular by taking action against them. But this is where I'm saying you cross the line. You have come to the court, you moved the court on migrant crisis. The court has said yes or no. You may criticize the court saying they are being too narrow in their view of the Constitution. The Supreme Court should have passed a judgment, should not have passed a judgment. That is all, of course, legitimate criticism. Members of the bar can criticize, saying, no, this judgment of the Supreme Court is wrong. I may think it's right, you may think it's wrong. But to say that the court is doing this to sort of please the government or to cut out of the government, or that this court is not able to face up to the government, that is where I say is wrong. And the Solicitor General's criticism calls for some sober introspection. Have we reached a stage where certain people who have got used to using the court for pushing their own agenda, when they do not get success in court, they do not criticize the judgment. They try and destroy the integrity of the institution.
Some problems, the mic.
My mic, or you can't hear me? Can you hear me?
Yes, sir. So there was some scrambling in the sound, sir, and yeah. I think it's better now.
Yeah.
No, I'm sorry. That is perhaps at your end. I'm sorry. The sir's video is going perfectly fine.
Okay. I'm sorry. Yeah. I'm sorry, sir. Please continue.
Yeah.
Sir,
Sir's video is perfectly fine. It's fully audible. Yeah. There is some at your end. Huh.
No, what I was trying to say, at a time like this, yes, where the whole country is on tenterhooks, people are moving the court. The judges have to draw their own conclusions of how far will they go and where will they defer to executive wisdom. It's a very, very difficult decision on a case-to-case basis. And hindsight may say in 20/20, the judges went too far or the judges didn't go far enough. And we will all examine these judgments. But to say that the judges are not doing this because, or that they have failed, or that they have lost their soul, or to say that this has become an F-grade institution, I'm sorry to say, this crosses the line. Should it be actioned is another matter. Most of these comments are best treated with the contempt with which they deserve. As Justice Mukherjee had said about the late Shri Shiv Shankar's comments, we treat these contemptuous statements with contempt. But there may be some cases, like the Andhra cases, where a message has to be sent.
Yeah. Absolutely, sir. So thank you for that wonderful exposition of how this should be dealt with. Most of the cases, I think we value free speech in our country rather highly. So we need to protect on the one hand, legitimate criticism of rulings, and on the other hand, we must draw the line where it becomes abusive or irrational personal attacks on judges that undermine the entire integrity of the institution. So I would like to draw your attention to certain examples in our Indian courts. So, and one of them or a couple of them you have been a part of where your suggestions were taken, sir. So India's fair share of incidents have taken place since independence, especially in politically sensitive matters relating to riparian disputes, NRC, Ayodhya, land acquisition, to name a few. Several instances can be quoted as examples. The Supreme Court has although expressed anguish and genuine concern on several occasions about the attacks from lawmakers, journalists, senior advocates, and anonymous individuals on media platforms. So why do you think it is not translated into any strong action? So before that, I take your answers. I'll just highlight 2 or 3 instances of what the Supreme Court justices have said. Very recently, Justice Nariman expressed great displeasure and criticized the violent agitation that broke out in Kerala after the Sabrimala verdict, when he said compliance with the Supreme Court judgments is not optional. Justice Chandrachud and Justice Nariman said bona fide criticism of the Supreme Court judgments is permissible, but organized efforts to subvert the judgment cannot be allowed. Similarly, Justice Chandrachud had remarked with caution regarding what his interns told him, and frankly, sir, this is quite scary. And I quote, "Please don't be on social media. It's scary. The amount of vile threats, abuse which you have received, it is scary." And this is personally to him. He further added that it is a part of the system and we as judges should have broad shoulders. Let people give vent to whatever they feel about a judgment, because we are dealing with the difficult issues which are difficult for us to take a call on as well. Justice Arun Mishra too responded to severe criticism on platform cues from the land acquisition matter. He said that the section of people are carrying out a concerted campaign on social media to malign him. Chief Justice Bobde, in a different context, referred to the backlash that during the Delhi CAA riots, and he said that we can only deal with the situation after it occurs. The kind of pressure on us, we can't handle that. It's like the court is responsible. We are reading newspapers, we know the kind of comments that are made. Courts come on the scene after the thing is done, and the courts have not been able to prevent such thing. Earlier, sir, in a different context where sir, you were personally present in court, in 2017, such comments on social media had come under the scanner where a bench comprising Justice Deepak Mishra, Justice Kanvilkar, and Justice Chandrachud observed that they should sit in Supreme Court and see how the government is hauled up. Further adding on to it, he said that earlier the right to privacy could have been infringed by the state only. Now such things emanate from private parties too. The concept of my house is my castle is fast fading due to the intrusion of private players. Justice Nariman also remarked that the civil laws in India were defective and there was an urgent need for some kind of regulation. So there are several malicious campaigns going around. So my question to you is, with such express and vocal agony expressed by honorable justices of the Supreme Court and other high courts, we still do not have a specialized system of preventing and investigating such excesses. What kind of regulation do you see in place for such excesses? Should the court only resort to its suo motu or epistolary jurisdiction and keep taking suo motu cognizance and prosecute under contempt proceedings, or should a specialized body be there? And in this regard, sir, the courts of the Andhra High Court, which you had referred to, become really relevant, where it was said that there is also fabrication of material with abusive, hatred, and contemptuous contents to cause incitement, disaffection, and ill will against the honorable judges. So I would seek your views on this.
See, our judges have expressed serious concern over the way things are going. And I would, speaking for myself, for a lot of people who make comments, they don't spare lawyers, they don't spare judges. I had made the mistake of joining Twitter for a month or two, and then I quit it because for the most I was being abused by people. For each person thought he had a right to decide which case I should appear in and what I should argue, and why I argued something, and did my conscience not bother me for having argued something. So each person today, social media, especially platforms like Twitter, and I believe there are other similar platforms, have put the power of publication in the hands of each individual. I had suggested to the government, and I keep suggesting this to the government. Government perhaps gets embarrassed thinking that politically it will be viewed as a way to silence people and therefore it shouldn't be done. I suggested to the government, you must have a tribunal for private defamation. So at least defamation cases can be concluded quickly. You know what happened in UK when the wife of the speaker, Mr. Burkhoff's wife, there was a nasty comment in one of the tabloids about one of the conservative lords, and she retweeted it only with the comment, he had it coming. He brought an action in defamation against us, and it went on a preliminary issue for trial as to whether that constituted defamation, and the court said it did. And it said, I'm leaving it to the two of you to try and settle the damages, otherwise I will hear the case. They settled. In UK, as you know, in the courts here, in the Chancery, they have given instructions. As far as possible, private defamation cases have to be finished in 6 months. And they are fast-tracked. In India, you file a defamation case, and it can go on and on and on.
Yeah.
Mr. Prashant Bhushan had passed some very derisive comments against Justice Kapadia. Justice Kapadia was known to be one of the most bold, forthright and impeccably honest judges about whom even the gossip mongers wouldn't gossip. For a judge like him, because you did not like his verdict in one environmental case, to call him names, Justice Kapadia expressed great anguish in court. The Attorney General did not act. I moved, as an amicus, I moved a contempt. Justice Kapadia is no more with us. That contempt is still pending. So we are not serious about dealing with all this. I had suggested to the government have a tribunal for private defamation. Not defamation of the public kind. You can create an exception for making comments on people who are in public office. So it will not be seen as the government is trying to suppress dissent. But if you make a private comment on somebody's private life or on against a private person, that should be actionable. Nothing has been done on that score. Other than that, when it comes to judges and when it comes to criticism of this kind, I think you have to have three broad divisions. One is each person who has a Twitter account and who thinks he has a right to pass commentary on any and everybody in the world. When people like that start passing nasty comments on judges, that is one area where I think they are best ignored. I believe there's a word for it called the trollers. I believe they are best ignored. I think younger members of our profession many times take these people on and correct them. The second is people who are in a position that they hold sway over public opinion, and I put them in two kinds. One is you may have people who are in socially important places. Today, as you know, in India, quote unquote, civil society has come to occupy a very important space. Now, people who claim to be part of civil society, who are vocal, who are seen, who are heard a lot, and whose opinion matters, and people who are in government, who are in political office, who by definition are therefore people who communicate with the masses and who are people who try and mobilize public opinion. It is when people like this pass comments, it has to be seen very carefully. And I would classify it into where government or people in government make comments about the courts, it has to be viewed very seriously. Because that is upsetting institutional balances. Now, when I say it has to be taken very seriously, I don't mean you have to be hypersensitive to comments. What constitutes contempt is very different from how seriously should you take a contemptuous statement. And if it comes from, as the Andhra case, I'm sorry, I go back to the Andhra case, as I have seen people of a political party who are angry because some judgments have gone against the decisions of the government of the day. And you start abusing judges, calling them casteist, calling them all sorts of things and threatening them, that has to be taken extremely seriously. These people have to be taught a lesson to restore the credibility of the institution. Otherwise, for a common man, if the local MLAs can all get up, or if the local people can all get up and abuse the court, what respect will he have for the institution? You've then effectively taken away one pillar of democracy. Secondly, people who are movers of public opinion. And I go back to the Solicitor General's comments. Today we have, and this was one of the biggest concerns of public interest litigation. A lot of people feel that even if they are not elected to office, they can use the courts to impose their will on the government, or to impose their style on the government, or bring cases in which you can get political brownie points. Courts have to take in their own judgment decisions on when to interfere and when not to interfere in public causes. You may criticize a court as being conservative in a case where you feel it should have interfered but hasn't interfered. But to again cast aspersions by ascribing motives, saying that the court has become scared, or the court is no longer being robust, or that the court is no longer being courageous, is accusing judges of being timid. I can say intellectually you have got it wrong. You are giving too much deference to the executive. That's a constitutional concept, deference to the executive. To say that you are scared to take on the government is a very different thing.
Yeah.
So that is where we have to draw the line. Ignore the trolls, as Justice Chandrachud said, our shoulders are wide enough. But where significant people make comments, you have to deal with them.
Yes, sir. So I think you say something very, very important, that because people being well known have more followers and it's likely to tarnish their reputation even more. So they should be held to a higher responsibility and perhaps be brought swiftly to action so as to avoid and possibly made an example of. So I would want to see a situation where such people who where they make reckless statements, they should be put to the task and made an example of. So I would like to ask a question, which is a sort of a contra viewpoint. So in my limited years as a lawyer, I have observed that there is a tendency and sort of compulsion to conform, which pervades all sections of society, and which even the judges even fall prey to. And so this is the compulsion to say or do not what is right and what the correct position in law tells them, but what is proper according to an external standard, often imposed by media platforms or other shared beliefs. All relevant classes play to such galleries and seeking approval from press and social media trolls, and the ability to make bold and right steps is often compromised. The casualty in all of this is truth, fearlessness, and candor, and many a time justice. So, what do you feel about this as a contra viewpoint to what we just discussed?
In fact, it is not a contra viewpoint, Namaskar. Let me tell you why. If there are, yes, there may be some judges who may not want to read any criticism of this kind, and therefore, when you're giving a judgment, it goes into the scales. Some of our older judges used to say, we don't want to read the newspapers because we don't want to know what people say about what we decide. We decide what we think is right and let people do what they think is right. There are some judges, yes, who may be concerned about the consequences of their decisions. There is always also, as we acknowledge the famous expression, judges bring their can't helps to court. We have you would have seen, I've seen over the last 4+ decades I've been around in the game. Some judges are very pro free speech, some judges are against free speech. I remember moving a matter where, against a sitting Chief Justice of the Andhra High Court, a journalist of a very eminent channel, eminent journalist of a very well-known channel, had given a questionnaire saying, sir, these are the allegations of corruption against you. I want to do a story. This is my storyboard. I would like to give you the option to comment.
Yes.
The judge marked it to a brother judge who constituted a bench, issued notice in contempt and injuncted publication. I brought an appeal which was being heard, and I don't want to name the judges. And I thought this appeal should take 30 seconds to be admitted and stay to be granted. One of the judges said, Mr. Salve, what does your client think? He can produce stories about judges. I said, this is not a story. That is why he has asked the judge for his comments. And if the judge says they are completely false, my client will have to go back to the drawing board and decide that in the face of a denial, does he still want to carry the story? Because then he knows he's running a very big risk. That if it turns out to be false, he will take the consequences. He says, look at your language. You're calling it storyboard. I said, I'm sorry, that's a technical expression. A storyboard, it could be a true story. I mean, all stories are not fiction.
Absolutely.
And they said, no, how can you write about judges? See, this So some judges are conservative and bring they can't help. Now, was that judge saying it because he was of the same caste as the judge in Andhra High Court, or was he saying it because he was of the same community? Of course not. He was a narrow-minded judge who thought that was the width of free speech. So all judges bring can't helps to court. But at the same time, when you have this kind of unmitigated badgering of courts by people who hold sway on public opinion, and it is not contained, it will affect the working of the system. And let me tell you where it will affect the working of the system. Ultimately, the power of a judgment is the power of public opinion. If I fight a case and I lose, I should have the confidence to accept that I tried my case, but it went wrong. I should not go home thinking the judge was worried about what the newspapers would say, and that is why he decided against me. The day I get that feeling, you have eroded my faith in the judiciary. So we have to be careful while not being oversensitive. Goes back to the broad issue which I was making, where people in high office start attacking institutions in a way that the people who are the consumers of justice start feeling, see, and anybody who loses a case in court goes back unhappy. He should go back at least with the feeling that, well, I'm not happy with what was done, but well, an independent man, an honest independent man felt this way about my case. I'm sorry he felt this way about my case. If that man goes home feeling that that fellow knew in his heart I was right, but he got scared because what the newspaper would say tomorrow, that will undermine faith in the judiciary. And that is why we have rules, for example, covering criminal trials. Why do we say in the currency of a trial, the media should not run a campaign? It is not whether the judge is being influenced, but will people feel that the judge got influenced? You're undermining the credibility of the process. So that is what we have to be careful. Keeping in mind this broad distinction, trollers can go on and say whatever they damn well please. But keeping in mind this broad distinction, we have to be very careful. And if we do nothing about this growing menace in India, and it is a growing menace, people come to court with a point of view to say we will show the government and we will show them in a bad light. You file a case. If it goes against you, you go public and say this court is sold to the government. This court doesn't have courage. These judges are useless. These judges don't have the courage to stand up to the government. So I was right. If the judge doesn't agree with me, he's dishonest. Because if you don't say a judge has stood up to the government, what are you saying? You're saying he is dishonest. He's intellectually dishonest. He has taken an oath of office saying without fear or favor, but he is acting in fear. So he's being dishonest. This tendency must at some point be curtailed, and we owe it to the system. Your generation, my generation, we have let our institutions down. Let me make no bones about it. We have let my generation has let down the institution. Your generation has to be more alert and more careful, because the power of the media is very different. When we were young lawyers, you had 3 newspapers, and they were very, and they were all very conservative. Today, with social media's explosion, half of us don't even know how to handle social media. Yes. Your generation has to be very alert to this growing menace. Otherwise, 20 years from now, you will have no court to practice before.
Absolutely, and it discourages younger lawyers to take up the job of becoming judges. So you just referred to, sorry, sir. So you referred to a trial and how the judges, the media should not over-report trials. So what are your thoughts on the sub judice rule today, and which seems to have been reduced to vanishing point? and which is even fueled more so by the rise of social media. So it's a sort of a connected
See,
question.
I feel, especially in criminal law, I feel very, very strongly that what we have in India is a complete travesty. And believe me, I know this for a fact. Your investigation agencies are completely off the hook by using this trial by embarrassment instead of trial by court. Today, people want, the media wants, and the angry people who have all the time in the world to dominate this space of social media, they want instant justice. So allegations are made. You first make allegations against a person. It goes to the police or it goes to an investigation agency. That agency is very sensitive to criticism. So what is the soft option? Register a case. Damn the reputation of the person involved. Then the pressure builds up. What do? Arrest that person. So you arrest that person, and the way media covers the arrest of that person, you would think he is being sent to the gallows. We have forgotten that it is being arrested in a jurisdiction which you can act on suspicion. Thirdly, and I make no bones about saying this, somewhere along the way, we have completely lost the soul of the law of bail. This overall feeling that where there is an economic offense, you should not grant bail, where there is an allegation of corruption, you should not grant bail, overlooks a basic fact. Our conviction rates are pathetically low. Cases of false allegations are rife. There is no reason why bail, not jail, should not be the rule, even in economic offenses.
Yeah.
But why do we refuse bail? Because if a judge grants bail, there's a, oh my God, this big criminal has been brought and he's been granted bail. And I feel that at some point we need to sit back and think about where this has gone wrong. But that's a different discussion. The kind of hydraulic pressure this brings upon the system is one. And the second is the perceived hydraulic pressure. Should a person denied bail go back into jail feeling this bloody judge got scared of the media?
Yeah.
See, then you're losing faith in the system.
Absolutely.
What will he then try to do? Then he will try and buy 5 newspapers to write different articles. So,
yes, sir.
Or he will try and say, okay, can somebody speak to someone and do something? That's where things start going wrong. That's where things go off the rails. So this media interference in criminal investigation, in criminal trials, and especially once you have reached the court, public trial is one thing. Having a running debate on a day-to-day basis with 5 panelists sitting and discussing what the evidence was, I think is ridiculous.
Absolutely.
I remember once when Colonel Purohit was granted bail, and Mr. Srinivas Jain, the famous anchor, he called me. And he started mentioning, but sir, how could he have been granted bail? This happened and that happened. And I only smiled and told him, I said, Srinivas, you were so well prepared. Why didn't you replace the additional Solicitor General and argue the case of the government? I mean, considering you think that he's an idiot and the 2 judges sitting there are idiots and you're the only one who knows what the law is and what the facts are, you should have come and argued the case. Then, of course, he backed down. See, this is what goes on. So a media anchor has made up his mind that so-and-so shouldn't be granted bail. So if a lawyer argues and loses, that lawyer is an idiot. If the judges grant bail, the judges are an idiot. And you're discussing it point by point and saying, how did this happen? And what are you trying to suggest? What are you trying to suggest? That you sitting in the media have more brains than all those people there? And the tone and tenor in which this is discussed. If there is a judgment, by all means criticize it and said this man has got off because of a flawed judgment.
Yes.
But not to say in a discretionary order of the court, how could the court have done this when? So
they seem to become a special legal experts, sir, when it comes to, and with great forensic skills. and it's amazing, sir, the kind of debates that go on nowadays on the regular channels. It's like a media trial and much, much worse. So I would go to the next question, sir, which is sort of a different source of attack for the judiciary, and it's a topic of heated debate when it comes from the government to further its own political agenda. This, though, is indirect but however clearly demonstrable on certain occasions. So, how do you feel the need for and the necessity for an independent ombudsman outside the control and clutches of the government executive powers, government, and does not rely on the government for infrastructural support to regulate the possible invasions of privacy by the government entities and also private entities on certain instances? And so, independence of the body should be a key.
I think there is a very strong case made out for a privacy regulator of a powerful body, obviously independent of the executive, who must have the right to examine violation of privacy. But when we all talk of violation of privacy and what goes on, and when we hear all these solemn lectures and some of the judgments especially, I always want to play a party spoiler. All of us love gossip so much that many times when you have an opportunity to fix a problem, we don't fix it. Neera Radia's case. The law is you can tap somebody's phone if you're looking for a specific offense for a period of time. And during that period, when you tap a phone, somebody has to make the effort of going through the conversation, finding out what is relevant, keep what is relevant, and deleting what is not relevant. Nobody has a right to store private data of a person. The very fact that the Neera Radia tapes were in full available with the tax department was a serious infraction of the rules. Then you require review. The person authorizing wiretap copied the rule, whereas in the interest of preventing an offense and this and this and this and this, you do not have to be a great guru in constitutional law to read that, or a guru in administrative law to read that and say this is absolute nonsense, it's a non-application of mine. The review committee did exactly the same. With the result, for 3 years, a bunch of telephones were tapped. What did the court do about the fact that how dare the government tap phones for such long periods of time? What action has the government taken against the people who are supposed to be custodians of this data? How did it leak? And what is the government planning to do? The Supreme Court was not interested in any of that. The judges hearing the case were only interested in what did she say about whom and why should we not have it investigated. So if this is how we are going to treat concerns of privacy, then this is lip service to privacy. So we must have a powerful adjudicator, and we have in India what we call, we don't follow the rule of the fruits of the poison tree. So even if there is violation of privacy laws, if you discover the commission of an offense, that evidence can be used. But the person who has illegally collected that evidence must separately be tried for violating a citizen's rights.
The ends cannot justify the means, sir.
Correct. See, so in America, that evidence would be excluded. We follow the British model by which illegally obtained evidence can also be included. But the fact that somebody has illegally obtained evidence and violated my privacy is actionable separately. I may still be convicted of a crime, but the fact that somebody broke into my house is still trespass. And that person has to be dealt with in accordance with the law. We don't do that. I moved a petition in the Supreme Court once because we had filed a case in the High Court saying the tax department has leaked information about a raid, half of which is false. The High Court dismissed it. The Supreme Court said, no. Ultimately, if we impose damages on them, it will come from the taxpayer. I said, that means what? That the officers can get away, recover it from their salaries. They said, no, it's okay. So we as Indians are not serious about privacy. We only talk big. We give seminars on privacy. When it comes, when push gets to shove, we have never stood up for privacy. I think that mindset has to change.
So that's extremely helpful that you point this out, sir, because especially in the context of the government versus the judiciary, there are a lot of times when information which is private to judges, which may be used by the government to seek ulterior agendas and motives. So that is very helpful on that, sir. And I think you reckon and you are welcoming a law which deals with the adequate storage, disposal, dissemination of data
Absolutely.
in a proper manner. And people who use such data, who are responsible for such data, held responsible.
My private data is a very important, very valuable property which you are the custodian of. If you treat that property anything less than what you would treat the most valuable property, it should be an offense no less than breach of trust and conversion with 9 years or 11 years of imprisonment.
Yes.
If you are going to gather,
unfortunately, sir, it's not perceived.
If you are going to gather,
it's not perceived in that way, sir.
Yeah, it has to be, because it's all very well to give these big lectures, and a lot of these people who sort of give these big lectures about the right to privacy are themselves party to invasion of privacy.
Absolutely, it's a hypocritical sort of situation going on. So I would take you to the next question, sir, which is, so you already referred to it in passing, which is another source of attacks when it comes from former colleagues or retired judges who comment on social media regarding the internal functioning of the Supreme Court or other high courts or any actions of a particular judge. Their views, like senior lawmakers, are taken very seriously, especially coming from inside the system. And should there be any regulation or self-restraint protocols for former judges strongly commenting, even strongly, fairly commenting about judicial affairs, at least until the cooling off period?
For me, there cannot be a cooling off period. If you have been the member of an institution and you have been privy to the internal workings of the institution, there is an element of responsibility which you carry. Unlike the rest of the world, our judges, till their last breath, like to carry the epithet justice and want to be called Justice so-and-so bracket retired.
Yes.
You will see, nobody does it.
Yes.
No retired US Supreme Court judge does it. Even
Yes.
in UK, the retired president of the UK Supreme Court just calls himself Lord Newberger, and Lord is, as you know, it's a title. It's not nothing to do with the office he has held. But we have a convention that our retired judges like to be called Mr. Justice till the end of the days. Because if you want to carry that epithet with you, you carry with it the responsibility. You're telling the people that I have been a part of the system. And if you have been a part of the system, by all means participate in a debate on a repair to the system. But be careful, your comments will be taken very different. You have to be a team player as a judge. You have to be a team player. You cannot be on your own. Like in a government, there is a degree of collective responsibility even amongst judges. We sit in benches, otherwise the court is one. Like the government is one. Can a minister make comments on social media about a colleague? Would that be acceptable? I think judges should set a higher standard rather than a lower standard. So this is, I feel, something which, and this is the recent trend. In the past, you never had judges. save and except in very, very extreme circumstances like Shivkant Shukla or something, where it got to a point where also you will notice the comments of the retired judges were that we are sorry that the Supreme Court took this view. Nobody said anything about Justice Ray or Justice Chandrachud or whichever judges sat in that bench. They said something about the judgment. Yes, as a retired judge, you can always criticize a judgment saying this is too narrow, this is too broad, I don't agree with this, I agree with this. Of course you can. Judgments of the court are fair game for anybody, but not in this way. And attacking the institution saying because they are not acting in a particular way, I call the institution grade F or I give it F. Or, I mean, you're trying to write about the judgment and say what's wrong with it.
Even if you defer on reasons, but don't defer on something which is malicious. So you would recommend a sort of an informal convention or a code, which
we have to see. There are a lot of Avishkar. Ultimately, why is it that people say democracy is a very fragile virtue? There is a lot in democracy which has to depend on the good sense of people. Look at United Kingdom. They don't even have a written constitution. In theory, we are in this country, we live in a monarchy. And yet, could the Queen ever think of disobeying a judgment or overriding a judgment? And why would she not do it? Because she knows the British people will not accept that. That's not her role. So there are a lot of virtues of democracy which have to come from your heart. That's why Mr. Palkhivala had a very lovely phrase which he used to use. He says, democracy is a ceaseless endeavor. It is not a safe harbor. We have to always remember that.
Thank you, sir. That's a really wonderful one, and that's surely a keeper for future reference. So I would take you to my penultimate question, which is regarding the advent of social media and the focus in courts, which is on containing electronic device, and rather than banning them and banning the use of social media, they want to regulate it. So we now allow, frequently press officers in court. We allow fair reporting of court proceedings. So what do you think, and with the advent of current online virtual hearings happening, sir, what do you think is the need of the hour to create a transparent yet a fair reporting mechanism, and how do we balance that? So do we have a court-appointed officer, would you recommend, or should we have some sort of designated repository of information, which is the only official version of the Supreme Court's record to be published?
See, I have this is something on which the jury is out, and let me tell you what happens. Two incidents, one of which of which one of them maybe you were part of one of them, if you remember. If you remember when we were arguing Vodafone.
Yes.
Somebody published saying Mr. Salve argues, yes, my client did evaded tax, but so what? And next morning there was havoc when the offices opened in UK, 12 o'clock around noon India time. Our clients got desperate messages saying, did he really say this? Because how can we as a listed UK company even make a statement like this? And you remember I brought it to Justice Kapadia's notice, and he took serious exception. It turned out to be a PTI. And when I called the PTI person, he says, my youngster, he was running in and out. And he asked somebody, and he said, this is what Mr. Salve argued, and he went and published it. In fact, going back, if you remember, when the Ambani battle was going on, and Justice Ravindran was on the bench, and one of the questions when I was arguing, he asked me was, he says, it says a suitable arrangement will be made for supply of gas. And what if parties can't agree? Will it go by arbitration? Or, I mean, who decides whether it's a suitable arrangement? It was an important legal question because you were arguing the High Court had no jurisdiction to give those directions.
Okay.
Immediate news flash, Supreme Court recommends arbitration between Ambani brothers.
Complete misreporting.
Share prices of both companies started being affected. Now, this only brings out the need for ensuring media organizations send authorized reporters, and the organization takes responsibility for irresponsible reporting. I think the media organization should get together and write up guidelines of what should be reported, what should not be reported. And one thing which should definitely not be reported are comments made by judges. It has a chilling effect. It has a chilling effect on advocacy, saying if I say this, the judge might say this, and what will tomorrow's newspaper say? The judges also feel that if you are asking questions and if it gets reported, many times you may change your view and then it looks like, Supreme Court slams so and so. It is an expression which we hear so often.
Yes, sir.
Court
And
ne phatkar lagai.
the comments taken out of context.
Judge is
Completely.
asking you a question, you're giving an answer. A judge will speak through his judgment, but today you declared phatkar lagai because he asked a difficult question. So, all this has to stop. We need to have a code of conduct for court reporters and authorize them. And you must have, the media must set up its own ombudsman. And if they misreport, complain, and if it is found complaining, take away the accreditation of that journalist.
Absolutely. So these comments taken out of context sometimes can be very funny, and they can change the entire scenario, and the media will focus on a different issue.
A judge may be asking me very hard questions, but my skill as a lawyer is to rise up to the moment to answer those questions and turn him around. If you report them as a judgment to the Supreme Court, what is people are feeling? Oh, so overnight the judge changed his mind. But that's what the whole bloody process is about.
And they will be afraid to speak their mind in the future. More of.
That's why many judges, in fact, Justice Ravindran came next day to court and said, I was told this has happened. Then he asked me, I said, yes, my lord, my clients have also told me this happened in the Reliance case. And he said, I appeal to the media people, please don't do this, otherwise we will feel embarrassed asking questions.
This really calls for a change in the way we report. So,
absolutely.
Sir, almost my final question, sir, before just concluding with a small follow-up question, sir. This was, sir, regarding, there are, as you have seen, sir, all kinds of people on social media, the good, the bad, the ugly. And the problem is really with the volume of content that is today available on social media, and sifting through that content and being able to spot that this is abusive and this is not abusive, this is merely legitimate criticism. So who must take, in your view, such responsibilities? So as you're aware of Shreya Singhal and the safe harbor under. So who should take the responsibility? Should it be the intermediary? Should it be the or the platform, or should it be an independent appointed body which actually is empowered with the task of looking and regulating this content? So what is your view? And so how would that be balanced with the constitutional right of free speech?
See, the problem about the carrier taking sides is very serious. The safe harbor rule means you carry whatever somebody says, unless it is pointed out to be abusive or this, in which case you take it down. President Trump's comments on Twitter raise an important issue. I mean, his way of saying things is a little abrupt and a little brusque. But what he said is that he is making comments. Is it for the carrier to start doing fact check? That means then, as they say, you are no longer a carrier and then you're in the battle. So this is a matter of considerable complexity, because this is also new. But my feeling always has been that it cannot be either the obligation or left to the carrier or the other platform, but there has to be somebody like a tribunal to whom I can complain if I have been slandered by somebody, and who in appropriate cases must have the power to take action. It's all a part of the defamation the larger remedy for defamation and an effective remedy for defamation in India.
So you would recommend a private tribunal when it concerns the judiciary for redressing such claims. That's extremely helpful, sir. So the one recent event that took place of a very distinguished, really fierce, well-known Delhi High Court judge, so which I don't want to miss out, and I want to take your views on it. He was recently transferred to Punjab and Haryana. And in the midst of the transfer, there were huge campaigns going. Some were actually to the point of ridiculing his character. Some were personal. Some were favoring him. So all kinds of stuff going around in social media. So at that time, sir, does it not hamper and does it not affect the credibility of the judge where he is now placed and the transfer system now? So I just want to take your views on that.
That is exactly one of my I have always been a trenchant critic of this present system of appointments and transfers. And this is one of the reasons why I have been a critic. The court lacks the equipment to select the right personnel, and the court is not the institution which is designed to take this kind of slack. If this power of transfer is wielded by the court, both in appointments and in transfers, the notion of transparency may at times be a remedy worse than a disease. Can you imagine if suddenly tomorrow you find the name of 10 lawyers saying of these 3 are being made judges, 7 are not being made judges because they were not found good enough, young lawyers. How angry will those young lawyers feel saying, we don't know who asked you to consider our merits behind our back and give these kind of comments. Same with the transfer. Many times, would you want the reasons recorded by those judges for transfer to come in the public domain? I don't think so. They may be right, they may be wrong. So that is why we need a National Judicial Commission to deal with appointments and transfers. And till you have that, till you have a credible judicial commission, insulated from the government and also not subject to the court. If you have such a commission, a lot of these problems can be avoided. Till the court continues to wield this power, you will invariably have these kind of problems.
You'll have to unmute yourself, Avishkar.
I'm sorry. We just lost you for the last bit, sir.
No, I think your thing went off.
Yeah.
A similar mechanism was in place in a judgment of by the Supreme Court, where they said that all complaints against any platform, any information prevailing on the internet, Sir, are you able to hear me?
No, your voice is breaking up, Avishkar.
Avishkar, you can send the question to me. There is some internet connectivity issue at your end.
Enriching lecture. We've got several takeaways from it. We would be in the near future publishing it in the form of some work. And I really thank you for taking out your time, sir, amongst your busy schedule from the UK. And we will share all the detailed notes with you, sir. This will be a proper transcript. And fortunately, sir, we will be fairly reporting what happened today. So we are glad that this social media will be put to good use as opposed. I
Thank
would
you.
transfer it to my friend Abhikal, who is going to be giving the vote of thanks for today's illuminating and enlightening webinar. Thank you very much.
Good evening, sir.
Good evening.
Sir, before I go for vote of thanks, I will request Siddharth sir. There is a very interesting question which I can see in the pop-up. I will just request Siddharth sir to take up that question, sir. Siddharth sir, please.
Yes, I am sorry for this out of turn question. Perhaps this came up in the query box, chat box. It reads thus: the Supreme Court has been at the receiving end a couple of times of unfettered social media notoriety over the recent issue of 4G internet connectivity in Kashmir. Social media is infused and replete with contents undermining the authority and integrity of the court, enough to sway public faith in the judiciary, even to the extent of polarizing it, and even the judgment against the principle of justice. Could you please, sir, explain the extent of the devastation such instances cause? Does it create a situation where the judges may be forced to give consideration to public opinion instead of the letter of law? And if yes, then how do we deal with this perpetual and perennial problem in such cases which have politically sensitive overtones? This is the question, sir.
Siddharth, this raises a very this is a very important instance of what is going wrong today. There are a group of people, and that's why I said what the Solicitor General said in court requires very serious reflection. I have done a lot of public interest litigation myself, but I have seen in the last decade, when public interest litigation started spreading into holding politicians accountable, it opened up a completely new area where people realize the court becomes a good weapon to wield against political adversaries. And a lot of people started ruling the court through the judiciary. The first example of this, I call this an unmitigated an economic disaster for the court, was the 2G judgment. Yes, it is correct that there may have been something amiss with what the minister did. But when it was established in the court that what the minister did had no effect whatsoever on the selection, the court still quashed. Reading the judgment, I am completely unconvinced by the reasons given in the judgment. The coal lease case was again a political philosophy being administered through a court. And instances are rife in the last 10 years. Privatizations are challenged. Nuclearization is challenged. Where the court is put in the middle on some legal ground, basically your challenge and your battle becomes controlling government. And the court there was a phase where the court was controlling government very strongly. And there's an old theory, which I always have, which I call nature abhors a vacuum, where the governance shrank, and we had a period of time in which we had which we all call the policy paralysis, where government shrank. The court broke its boundaries and started getting into areas of governance. So nature abhors a vacuum. When governance shrinks, somebody else started governing, the court started governing. Now, when a new government has come, you're pushing the court back into its old bounds. And that is this process. In the meanwhile, you have a class of people, vocal, articulate, who got used to having their point of view almost at times imposed on the government through the vehicle of the court. Those people are sharply critical of what has happened in Kashmir. Kashmir is an issue. I personally am all for what the government has done, but I do acknowledge there is a counter point of view saying you shouldn't have done it. I may not agree with it, but that's a point of view. But that's democracy for you. Now, to use the court in a case like this, if you are genuinely in human rights concerns, and the court has said, well, this is the problem with the internet, and there is a balancing between safety and security and access to the net. You back down. Somebody may say, well, I wish the court had been more bold and interfered or not. But to then ascribe motives saying, look, even the court has abandoned the people of Jammu and Kashmir, as it were. Which means if you don't listen to me, I will pull you down. So your respect as an institution depends on how long you listen to me. If I don't have my way, I will destroy your credibility. This is what I have been speaking about. And this is the Kashmir judgment is one classic example why this tendency has to be curbed. And I think the best way to curb this, Justice Kaul showed the way that day in court. There are people who have publicly said we have no faith in Supreme Court. Correct? Next time when they come in a public interest litigation and they are behind it, say if you have no faith in us, don't come to us. You do what you have to do.
Right, sir. Thank you so much, sir. Now I will proceed to vote of thanks. Sir, I would like to take this opportunity to convey to you that we, the young lawyers of this country, have always seen you as Dharmarth of our legal profession. For our attendees, Dharmarth find its mention in Sri Ramcharitmanas, a chariot that always leads to everlasting victory in every situation of life. While explaining the details of this chariot, Lord Rama explains, Sauraj Dheeraj Tehi Rath Chaka, Sat Sheel Dhrad Dhwaja Pataka, which means that the wheels of life's chariot are valor and fortitude, quality of being dutifully firm, truth and good character are its flag and banner. So these are some of the characteristics that are vibrantly visible in your personality. Sir, and probably this is the reason, sir, you have been victorious in every sphere of life. Thank you, sir, for your valuable time. It was an honor and privilege for us to host you on our foundation's platform. So this foundation is helping the economically weaker students who are meritorious from all across the 25 national law universities in this country. Therefore, in future, we would request your blessing and support for them, sir. On behalf of the foundation, I extend heartful, thank you, sir. I extend our heartful thanks to Mr. Avishkar Singhvi for facilitating this exercise and for being a wonderful moderator. Before we sign off, sir, I would like to thank the whole team of students who have been working day in and night for the success of this webinar. Thank you so much, sir.
Thank you so much, sir.
Thank
Thank you.